State's response to defendant's motion for new trial. People have been awaiting this ever since that juror spoke. The state of Arizona, through undersigned counsel, requests this court deny defendant's motion for new trial, as there was no juror misconduct, no prosecutorial misconduct, no improper exclusion of hearsay testimony, and no lack of impartiality by the court. The state's response is supported by the attached memorandum of facts and authority. So here is that memorandum: facts, law, and argument. A. There was no juror misconduct. After the verdict, the jurors were released from the admonition and had to face a mob of journalists questioning them as they waited for the bus to take them to their vehicles. Juror number 15 was one of the jurors who was caught by the media. Juror 15 made multiple statements that were recorded by multiple agencies. Video on YouTube from Idaho News On Demand shows the first contact by the media with Juror 15. As he was exiting the South Court building, see Exhibit A, thumb drive containing YouTube video. In this video, there are multiple agencies rushing up to Juror 15. It is clear from the fact that you see the media running up to the juror that this encounter with the media occurred before the video cited by the defense, which was conducted next to the street bus stop. In the initial media contact, one of the media asked Juror 15 and another juror, were any of you folks aware that this woman had already been convicted of 3 homicide? Juror 15 responds, no, I did not. That is interesting. I wonder how Lori is going to think when it's Idaho News that is being used by the prosecutors to stop this, when she wanted Nate Eaton to be a witness in that trial and that was shot down. It's interesting. Juror 15 and another juror were then asked. There was a lot of backstory here. This woman had already been convicted of 3 homicides, and they obviously didn't want you folks to know that, and nobody knew that during your deliberations. Is that correct? Both Juror 15 and the other juror both say no. Again, citing Idaho News. Juror 15 was clear in this immediate contact with the media that he did not know about the defendant's prior criminal history prior to reaching a verdict. A few days after the verdict, Juror 15 participated in an hour-long interview with Lauren Mathias for her podcast. I'm going to mispronounce that so bad. Hidden True Crime. They have a link to it. In that interview, Juror 15 states that everyone was respectful of not telling him anything about the case while the trial was going on, that if anyone would have, I have put up a hand. During his hour-long interview, Juror 15 stated that after the verdict was read and they were released on the admonition, he started Googling Lori Vallow while still in the jury room. During the interview, from 15:30 minutes to 15:40 minutes, Juror 15 is asked and responds, if the day of the verdict you learned is that what you quickly Googled on your phone and you saw before you walked out of the courthouse? Yeah. That there were other murders? Absolutely. So you learned right then. Okay. I mean, I get what they're doing here, but the is like, I don't know. They're like, well, before he said he didn't, and then afterwards he said he didn't. But the defense is going to argue he lied about those times and told the truth on accident in between because it was so specific. That's what they're going to go with, I would believe. That's what they were putting out. This is what he said. During the interview, Juror 15 talked about not wanting to talk to the media when he was let out, but all of a sudden he was surrounded. And they cite the YouTube video again. Juror 15 was asked directly about whether or not he knew about the other murders prior to the verdict. But to clarify, you don't know how you knew there might have been another sentencing. Everything's a blur. I do understand that sometimes I forget what day, it is when I'm in attending trial, reporting a trial, but you did not know any of the other murders until after the verdict. And he responds, right, yeah, I had no idea of anything else she had been through prior to this trial, and even during the trial, I didn't know that. Again, we have to remember this interview is after the internet caught on fire with what he said. Not saying that he didn't misspeak in the middle, but you have to remember, this is, I mean, he would have a reason to lie at this point. I don't know. I've seen a lot of people think that she's not gonna, that this isn't gonna go anywhere. I don't know. During this hour-long interview, Juror 15 repeatedly stated that he did not know about the defendant's prior murders and sentences before the verdict in this case. Juror 15 spoke with multiple media outlets who accosted him as he was attempting to get the juror's bus. The videos provided by the state and Exhibit A listed as Idaho News on Demand is the first contact by the media with Juror 15, where he clearly states twice that he did not know the defendant had been convicted of 3 other murders prior to the verdict. The defendant is later interviewed for an hour on the Hidden True Crime podcast, where he advised that as soon as he was released from the admonition and while still inside the jury room, he was Googling the defendant. Juror 15 advised that this is when he learned she had prior convictions. When the juror was again asked if he didn't know the information until after the verdict, he again confirmed that he did not know anything before or during a trial. This juror was basically mobbed by media while just trying to get to the juror bus during this time. Juror 15 made one sentence that seemed to imply that he had looked up information about the juror's prior criminal history before reaching a verdict. Looking at all of Juror 15's interactions with the media, it's clear that he has remained consistent that he did not violate admonition. He waited until he was released from the admonition to immediately begin Googling defendants, and that he and the other jurors did not know about the defendant's prior convictions before reaching a verdict. I mean, that's the thing, right? Like, he said it, and yes, he was swarmed, and yes, someone could misspeak. But at the same time, it's a really bad misspeaking. Like, really bad. So, I don't know. Because everything after that, I mean, if he knew, theoretically, if he actually knew, he would have a reason to lie, right? And there are people that when they have a reason to lie about something, will lie, slip up, realize they slipped up, and then try to cover it. So, saying he only said it once, I don't think is an amazing defense, is what I want to say. Because, like, that's just a pattern of how people that slip up in a lie do it, right? Tylee, Ryan, and Alex Cox's statements were appropriately precluded as hearsay statements, and Detective Daniel Kuhn's expert testimony was based upon the physical evidence. In this case, the state appropriately filed motions in limine to preclude the defendant from admitting any statements made by Alexander Cox or Tylee Ryan, as these statements are hearsay and there is no exception that permits their admission. The court precluded the statements by Tylee Ryan made almost 3 hours after the shooting as hearsay. The court ultimately precluded any statements by Alexander Cox to the police from both when the police first arrived 47 minutes after the shooting, as well as the statements he made at the police station a couple hours after the murder. The state also objected to, and the court sustained as hearsay, any testimony regarding Alex Cox's walkthrough by police nearly 8 hours after the shooting. Detective Daniel Kuhn was noticed by the state as an expert witness to discuss the trajectory of the shots at the crime scene. During his testimony, the state asked Detective Daniel Kuhn, based upon his training, experience, and location of the casings, projectiles, bullet strikes, and injuries to Charles Vallow, if he could determine approximate location of where the shooter would have been standing when the 2 shots were fired. Detective Daniel Kuhn provided his opinion that the shooter would have been standing in the area between the curved wall, kitchen, and hallway. The defendant never established foundation that any statements made by Alex Cox or Tylee Ryan hours after the shooting were admissible under any of Arizona's rules of evidence. The testimony of Alex Cox and Tylee Ryan were appropriately precluded as hearsay during his testimony. Detective Daniel Kuhn gave his opinion as to the approximate location of the shooter based upon his training, experience, and the physical evidence to include the location of the casing, projectiles, bullet strikes, and location of the injuries of Charles Vallow, and the wound path trajectory through Charles Vallow. Detective Daniel Kuhn did not ever indicate that his opinion was based on the statements or walkthrough of the defendant's co-conspirator. So I think that's fine. I mean, I agree with that. I think it's a very solid response. I mean, to me, going into this, I thought everything that she stated she was trying to go was like garbage, except for the juror. I could see the juror being something that they could really toss up. It could be a worry. There was no discovery violation. On January 9th, 2024, the state disclosed the Cellbrite cell phone download for Charles Vallow's phone to the defendant. On January 13th, 2024, the state filed state's notice of disclosure and request for disclosure. The notice advised the defendant the state would use any evidence arising out of Chandler Police Department report, any information related to the case obtained from Cellbrite downloads, and that all requests to examine or scientifically test items of evidence must be in writing. That's January 13th. March 12th, 2025, defendant filed a supplemental Rule 15.2 notice of disclosure where she noticed an expert, Lonnie Dworkin. Defendant never provided the state any notice regarding Dworkin's testimony. On March 13th, 2025, the state was advised that Dworkin had not begun work. On March 16th, 2025, the state filed state's motion to preclude defense expert Lonnie Dworkin and preclude notice witnesses. The state filed a separate statement on support of Rule 15.7 sanctions due to the late and incomplete notice on defendant expert Lonnie Dworkin. On March 18, 2025, the defendant was asked by the court about Lonnie Dworkin. The state was advised that she could request continuance to allow time for her expert to review the victim's cell phone. The court further advised the defendant that anything expert discovered could potentially be precluded. The defendant was advised she wanted to proceed with trials that are seeking a continuance to allow her expert time to review the victim's cell phone. The defendant advised that she would like her expert to review Charles Vallow's actual cell phone. This was the first time the defendant requested access to this item of evidence. So it's just funny when they mention a continuance, because if you watched my other video going through the Sarah Boone appeal, it involves so many listings of motions for a continuance, which is why the case took so long. It's just a very big swamp. On March 18, 2025, the state emailed a stipulation to the defense investigator regarding the release of Charles Vallow's cell phone to defense expert Lonnie Dworkin to allow the expert to extract the cell phone. Jury selection for trial began on March 31st, 2025. The cell phone was returned to the Chandler Police Department on April 3rd, 2025. On April 7, 2025, while state and defendant were presenting evidence and testimony of the trial, the defendant emailed a motion to dismiss for failure to disclose exculpatory evidence and prosecutorial misconduct. The motion provided no facts to support that any exculpatory evidence existed, nor did it provide any facts to support prosecutorial misconduct. Attached to the motion was an affidavit from defense expert Lonnie Dworkin requesting the raw data from the Gray Tree extraction, among other items, Charles Vallow's cell phone. The defendant's expert did not advise that exculpatory evidence existed. It only provided the newer versions of Cellbrite might be able to locate additional data that was unable to be located in the 2019 and 2020 versions of Cellbrite. On April 10, 2025, the state provided the defendant with a thumb drive containing the Gray Key raw data for Charles Vallow's cell phone, iPad, and MacBook to give her defense expert. State has not received any reports, notes, affidavits, or information related to Lonnie Dworkin's review of his extraction of Charles Vallow's cell phone or his analysis of the Gray Key raw data. The state has not received any information advising that any exculpatory evidence was withheld from the defendant. Instead, defendant's motion for a new trial makes a conclusion without any support that the Gray Key raw data contained exculpatory evidence. Under Brady, the state must disclose all material exculpatory evidence in this case law cited. In this case, the defendant did not provide the state in writing a request to examine the Gray Key raw data from the extraction of Charles Vallow's cell phone until April 7, 2025. Upon this request, the state provided this data. Furthermore, the defendant has not provided any documentation to support the claim that the Gray Key raw data included any exculpatory evidence that was not part of the Cellbrite data that was disclosed to the defendant on January 9, 2024. Defendant's motion does not support a Brady violation or any violation of disclosure by the state. And then there was no prosecutorial misconduct. On April 8, 2025, the state elicited from retired Captain Kent Keller a statement made by the defendant while she was standing across the street from her rental home, approximately an hour after her brother shot and killed her husband. The statement made by the defendant is admissible under 803D2 as a statement by party opponent. Furthermore, the statement was relevant to show the defendant's demeanor during the investigation into the shooting of her husband. On April 21st, 2025, the court read the final jury instructions to the jury. The jury was advised in their opening statements the prosecutor and defendants talked about law and evidence. In a few minutes, the prosecutor and defendant will give the closing arguments and will talk about the law and the evidence. What they said or say it's not evidence because it's not sworn testimony, but it may help you understand the law and the evidence. During closing arguments on April 21st, 2025, the state made an argument to the jury about all three of the justifications of defenses: self-defense, defense of a third party, and crime prevention. The defendant has intentionally mischaracterized one sentence from the state's closing to claim prosecutorial misconduct. The state provided both facts and evidence to support why the defendant was not entitled to self-defense of a third party and crime prevention. During closing arguments on April 21st, 2025, the state made an argument to the jury based on a list of exhibits that July 9, 2019, Alex Cox made plans to have his brother Adam Cox stay with him the night of July 10, 2029. Alex Cox's plans changed later that night of July 9, 2029, when the defendant requested her co-conspirator Alex Cox stay close to her for the next couple of days. The state's exhibits show that Alex Cox did not answer his brother Adam Cox's calls or texts at 3:22 p.m. and 3:23 p.m. on July 10, 2029. Although the state did interview the defendant's sister, she told the state and Detective Duncan that she spoke with Alex Cox the night of July 10, 2019, and begged him to stay with the defendant. The state therefore was able to infer that since Alex Cox did not respond to Alex Cox hours before the defendant's sister spoke with him, that his plans to stay with the defendant were based on his discussion with the defendant on July 9, 2019. During closing argument, the state made argument to the jury regarding the defendant's demeanor from the time she arrived at the scene, almost an hour after shooting, through the time she was handed over the cell phone to Detective Yunkin around 3 p.m. on the day of the shooting. Witnesses described the defendant on July 11, 2019 as chatty, nonchalant, and unaffected by her brother allegedly being struck with a baseball bat, her husband lying dead in her house, and her children no longer having a father. The defendant's demeanor with law enforcement on the day of the murder was in complete opposition to the defendant's demeanor during opening statements, where the defendant attempted to testify as to the fact that were never brought in by the defendant during a trial, and crying in front of the jury. So, to go back up here, just to make sure we're clear, the defendant's sister, so Lori's sister, did message Alex about staying with Lori, but he had already stopped responding to Adam, so they are assuming he had already made plans to be with Lori because they were in contact, and Lori talked about how they need to be close and all that, which I think is a fair inference. The prosecutor is permitted to argue all reasonable inferences. Oh, I didn't even get to this page yet. I got the right word. From the evidence, but cannot make insinuations that are not supported by the evidence. And this is just case law stuff. In this case, the state did not argue or raise any matter that the jury should not have considered. Each of the inferences and arguments made by the state during its closing arguments were based upon the testimony of witnesses and evidence admitted at trial. The court remained impartial before, during, and after trial. The state filed 3 motions to preclude the defendant's noticed 15.2 witnesses. After each motion filed with the state, the court heard arguments as to the late notice, lack of the witnesses being available to the state, and their relevance to the trial. This court did not preclude most of the witnesses, even after multiple requests by the state. That's true. She had witnesses available. She didn't use them. One witness to the defendant's notice, Nate Eaton, is a reporter with no personal knowledge of the case. Mr. Eaton filed his own motion to be allowed to remain in the courtroom. Later, Mr. Eaton's attorney filed a motion with the court. The court heard argument by Mr. Eaton's lawyer and the defendant. Mr. Eaton's lawyer argued to remove Mr. Eaton from the defendant's list of witnesses and to allow him to remain in the courtroom during the trial. During this argument, the court asked the defendant why she needed Mr. Eaton, a reporter, for trial. The defendant indicated Mr. Eaton might be used to impeach a witness who testified. The court advised the defendant that she could impeach a witness with Mr. Eaton's recordings. The court also advised the defendant if she felt Mr. Eaton became a necessary witness, he would reconsider this preclusion, even if Mr. Eaton was in the courtroom during a testimony. The defendant never requested to call Mr. Eaton to impeach any witnesses. The state filed 2 motions seeking to remove Brandon Boudreaux from the defense witness list as a listed victim. In the other case, during the trial, the parties interviewed Brandon Boudreaux. In his interview, Mr. Boudreaux advised he was not aware that Adam Cox was in town or that Charles and Adam were planning an intervention. The defendant was unable to provide any other basis for calling him as a witness. The court struck Brandon Boudreaux from the defendant's witness list without prejudice, advising the defendant that should Mr. Boudreaux become irrelevant, the court would be open to hearing her argument. The defendant did not request that Brandon Boudreaux testify. On April 10, 2025, the defendant cross-examined Serena Sharp. The defendant asked the witness if several named people in the Bible were translated. The state objected to its relevance. The court allowed the defendant to continue questioning witness about this area. The defendant never asked Rena Sharp or any of the other three witnesses who were members of the Church of Latter-day Saints the Church of Jesus Christ of Latter-day Saints who testified during this trial if they thought it was a regular part of the Mormon religion for a current living person to be a translated being. Instead, the defendant merely asked one of the witnesses if there were people in the Bible who had been translated. And there's case law. Here, the defendant has admitted that the court overruled the state's objection, but argues that one comment by the judge during a 2-week trial somehow rises to the level of establishing by preponderance of evidence that the judge was biased or prejudiced. The defendant has not shown by any level that she was denied a fair trial before an impartial judge. That's the word trail, right? Anyway, this is about the judge saying, as far as you were comparing yourself to biblical figures or something to that, when she was like delving into the Mormon religion, which is fair because that's what she was doing, right? Lori was comparing herself to these figures, and that's why she was asking about these figures in court. It's what she was doing. If she didn't like that being talked about, she should have gone a different route. That's just that's not prejudice. That's a descriptor of what she's doing. She did that. She compared herself to biblical figures. That was the whole point of her argument. And if she doesn't like it being worded that way, how else did you want it worded? In conclusion, defendant's motion for new trial should be denied since the evidence supports that Juror 15 did not know about the defendant's prior felony convictions before reaching a verdict. The court properly excluded the hearsay testimony of Alex Cox and Tylee Ryan. The state's expert witness, Daniel Kuhn, relied upon the physical evidence at the scene and the autopsy of Charles Vallow to reach his conclusion as to the trajectory and general location of the shooter. There has been no discovery violation by the state. There's been no prosecutorial misconduct by the state, and there's been no evidence that the court was biased or prejudiced against the defendant. So, with all that being said, they did a good job. The best job they could with the juror, I think. I hope it's enough, right? I hope the juror just misspoke. And because they just misspoke, I hope this is enough. I really do. The rest of it, I mean, I thought it was nonsense to begin with, and they responded well. So I think everyone, again, even after this, is going to question, it kind of, I think, all comes down to Juror 15. Like, I think even if you read all of this and you're like, yeah, they'd refuted every single point, and you go, well, what was her best point if you had to give it the benefit of the doubt? I think it's always Juror number 15. So that's going to be to me, the sticking point. And if this doesn't go the way the state would like, I think it has to be on that merit, right? But when to get this video done, it's like the middle of the night. I finally found time to do it. I'm not going to premiere it. I'm just going to schedule it and get it up for you sometime in the morning. But thank everyone who tuned in. Hope you liked the video. Let me know what you think. Did you think they did enough to explain the juror situation? Do you think there's a chance that she gets a new trial from this? Like, of course, she's still going to appeal. I would leave this leading to a new trial as extremely low, but not 0. But that juror situation it's not even just about this trial. It's like public trust in the jury. I hate to go that route, but like, all it takes is that one statement. It's like, why was he in a situation where he was allowed to know this? Why wasn't it rooted out? Oh, they misspoke. Bad time to misspeak. So, we'll see. We'll have to see. Till next time.